when you're talking about proof of fraudulent intent, except in that rare case when the debtor says to your client, I meant to defraud your client. Okay? My next one of those will be my first one. So, you don't have the direct evidence, you have to have circumstantial evidence. And you have to have circumstantial evidence around the time of the event. I've ruled on this case, so I think it's okay for me to talk about it. I had a recent case involving non-dischargeability, and the alleged misrepresentation took place 1.5 years ago. And the evidence regarding the circumstantial evidence that was offered had to do with the filing of the bankruptcy, that there were certain inaccuracies in the schedules. Now, those are problematic, don't get me wrong. We like accurate schedules that we insist on. But the fact that the debtor had inaccurate schedules did not relate back to prove circumstantially that the debtor had fraudulent intent 1.5 years ago. It's got to be around the same time. It's got to be in connection with the transaction, something about that. Which leads to the second thing we want to talk about regarding this kind of misrepresentation. Silence can be a misrepresentation. If I say to you, I have $1,000 in the bank, that's an affirmative statement. If I tell you, well, if I don't say anything, you lend me $1,000, there's probably an implied representation there that I'm going to pay, and I'm going to pay you back. Silence can be a misrepresentation, but it has to be with respect to a promise to perform in the future. It has to be made with the intent to defraud, and it has to be made without the intent to perform. Without the intent to perform. And that's going to be the tricky part for if you're trying to prove silence was a misrepresentation. You have to demonstrate that the debtor never intended to perform. Circumstantial evidence, you go back to the time of the event, you come up and you persuade me that the debtor never intended to pay. It's a pretty tough standard. Non-dischargeability in general is pretty tough to prove. Proving an actionable silence is even more difficult. So you have to look at the cases and see what evidence has been accepted by other courts to demonstrate that the silence was in fact actionable. The second area under 523A4 is defalcation by a fiduciary. There are only two elements for this, that there was a fiduciary and that there was a defalcation. That's pretty straightforward. Bad faith, moral turpitude, other immoral conduct. Those are all examples of defalcation by a fiduciary. The Supreme Court recently told us that there's another possibility of proving defalcation by a fiduciary, and that's if the fiduciary consciously disregards or is willfully blind to a substantial and unjustifiable risk that his conduct will turn out to violate a fiduciary duty. You got a fiduciary, you have fiduciary duties. If the fiduciary is simply reckless in carrying out her fiduciary duties, it's entirely possible that damages resulting from that will be non-dischargeable. I haven't seen too many defalcation cases. We see the breach of fiduciary duty. We don't see the defalcation. One quick word about fiduciary. Don't want to see constructed trusts argued as a basis for non-dischargeability under this section. The requirement of a fiduciary is determined by federal law, and in the 8th Circuit, it has to be a pre-existing fiduciary relationship. You have to have a race, a separately identifiable race, and you have to have trust-like duties imposed on the alleged fiduciary. So you've got to look for those two things. If you don't have those, you don't have a breach of fiduciary duty. Okay? So the reason that we talk about this, and I'm talking about cases, is that if you go out and if you don't practice a lot of bankruptcy and you read 523 A4, you go, well, I think this guy was a fiduciary. My client trusted him. He was his attorney. Okay? He trusted him. Or he was an investment advisor. He trusted him. Trust isn't the issue. You've got to find a fiduciary, and you've got to be able to prove that. Now, 523A4 also has embezzlement. These four things are in the alternative. Breach of fiduciary duty, defalcation, embezzlement, and the fourth one is larceny. What we see frequently in complaints is that there was a breach of Section 523A4 without any reference to which of the four kinds we're talking about. They require different proofs. You need to be aware of that when you're drafting your complaint. Embezzlement is the fraudulent taking of another's property by a debtor to whom such property was entrusted. So you've got to demonstrate that the property belonged to someone else, that it was entrusted to the debtor, and that the debtor used it for some purpose for which it was not intended. We used to see this with the sale of collateral without paying the secured creditor. That's not embezzlement. The property belongs to the debtor. It's not embezzlement. You can't embezzle your own property. That's a fundamental statement under 523A4, so be aware of that. Larceny is a lot like embezzlement, except the original taking by the debtor was wrongful. Okay? For embezzlement, the debtor was entitled to have the property, used it for an improper purpose. Larceny, he took the property and used it for an improper purpose. Two sides of the same coin. My request in this area is that when you file a 523A4 complaint, that you think about what you really want to plead, what your facts are, and slide it perfectly. Section 523A6. This is the most often pled and the least often proved of the exceptions to discharge under 523A. Willful and malicious injury. Every client who didn't get paid thinks the refusal to pay was willful and malicious. And so I always see this in a complaint. It's almost like the attorney's gone to 523 and done a checklist. Well, this one's close, this one's close, this one's close. Everybody throws in 523A6. I have not accepted a debt for discharge under 523A6 in the 7 years I've been on the bench. I'm not sure Judge Hoyt ever accepted a debt under Section 523A6. And the reason for it is the case law is so demanding. The injury has to be both willful, and willful is defined as a deliberate or intentional injury, not merely a deliberate or intentional act that leads to injury. Think intentional tort. If it's negligent, you don't have a willful injury. 523A6 is not going to help you. Think intentional tort. Malice requires that the debtor's actions are targeted at the creditor, at least in the sense that the conduct is certain or almost certain to cause financial harm. The key there is the targeted. The debtor has to want to hurt the creditor financially. Okay? Think about that. If the debtor's trying to keep food on the table, probably not going to be able to meet the malicious element of this exception to discharge. If you think you have a case that involves willful and malicious behavior, I would encourage you to read the Patch case that's cited on page 7. It's an 8th Circuit decision interpreting 523A6. Read that case, and if you think your facts and circumstances are more egregious than that case, then file your complaint. But don't read that case while you're sitting down at the table. Don't read that case in front of small children. Don't read it in front of those who are easily offended. It is an atrocious case involving child neglect and ultimately the loss of the life of a child. And the 8th Circuit said that injury was not willful and malicious. So, read the case, and if yours is worse, take a shot. But if it's not worse, look somewhere else for your exception to discharge. I'm not saying I would never grant or find that a debt was willful and malicious. I'm just saying I've got a lot to be shown under 8th Circuit law before I'm able to accept the debt from discharge. Anything about discharge? Yes, sir.
Yeah, I have another question, Judge. Thanks. express or technical trust, I understand that under, I think under 5.384. I want to ask you two things. One is, do you believe the fiduciary duty needs to be imposed before the debt arose or just before the breach arose, as long as the causation is still there?
Okay, did everyone hear the question? Okay, I think that the short answer under 8th Circuit authority is the fiduciary relationship has to exist before anything. In other words, whatever the act giving rise to the liability has to take place after the fiduciary relationship was created. And I think that's what, excuse me, the Pretrial case.
And I saw that in the outline. I'll relook at that because it is instructive. Second question.
Now, I do want to say that that opinion, that was particularly well-reasoned and well-written.
Good deal. The second question is insolvency and that. Okay, so let's say I'm a director or main officer, president or something, corporation. It's insolvent. There's all this common law, and I don't know if you've had a chance to rule on that or had a need to rule on that. There's all this common law that, okay, now you're a fiduciary for the creditors as well as the shareholders. Do you think that would work under express and technical trust if the timing of the debt came later?
It will not. And again, I say that with some degree of confidence because of the Pretrial case. In Pretrial, there was actually Minnesota common law at play, and we're talking about the fact that a director under Minnesota common law, I think maybe in the Minnesota statute, had a fiduciary duty imposed on the director because of the insolvency of the company. And that was not found to be sufficient to make it, to create an exception to discharge. Because, again, there was no race, and there were trust-like duties. They talked about imposing the trust. But constructed trusts, again, that was a quasi-constructed trust, it seems to me, and those don't qualify. Exceptions to discharge are narrowly construed, and that's you'll see that in almost every opinion written on exceptions to discharge, and most judges, including this one, take it pretty seriously. The debtor's discharge is the goal, and exceptions are construed narrowly. I will say that within the 8th Circuit, particularly, and I'm not just saying my opinions on the BAP opinions in general, do a really good job on any of these exceptions to discharge. If that's the issue in the case, they will lay out the elements in almost every case. They'll lay out the elements that need to be proven right off the bat. So if you have a particular section and you're curious about what the elements are, a Westlaw search for that particular section in 8th Circuit cases, 8th Circuit bankruptcy cases, will get you the elements pretty quickly. They're pretty good about laying them out for everybody. Anything else on non-dischargeability? Again, something that the non-bankruptcy attorneys may not be aware of. The filing of a complaint objecting to the discharge, the entire discharge, stays the entry of the order for discharge. The filing of a complaint to determine dischargeability does not. So if you're not familiar with bankruptcy and you get a client and you file a complaint to determine dischargeability, and the clerk's office enters the debtor's discharge before your complaint's heard by me, don't panic, it's okay. That just means that all the other debts are discharged. Yours is still in play. Yours will still be heard by me. Had a couple of attorneys call up when I was the clerk and a tizzy about the fact that the debtor had gotten their discharge and their complaint had not been heard by Judge Hoyt at that time. Just want to call your attention quickly to under the debtor, does debtor have good partners? The Reuter case. This is kind of scary for those of you that have clients that are in partnerships. The standard in the 8th Circuit has always been that one partner's non-dischargeable conduct could be imputed to another partner, the debtor, if the debtor was recklessly indifferent to his partner's bad behavior. Okay, in this case, the Reuter case, the partner was running around selling these high-risk, high-yield, no-risk investments, which surprisingly turned out to be high-risk, no-yield and people were not happy about it, and the complaint was brought against the debtor for the partner's wrongdoing. And under the Eighth Circuit authority, because the debtor was a little bit shady himself and had in fact been, I can't use that word, cheated by his partner himself, then the Eighth Circuit said that the debtor was at least recklessly indifferent to his partner's wrongdoing and held the debt was non-dischargeable as to the debtor. So if you've got clients and partnerships out there, if for no other reason, encourage them to keep an eye on their partners, because if those partners ever do something shady, those debts could be found non-dischargeable as to the debtor. That's got to be a real surprise. Now, the scary part about the opinion is, as I said, in the Eighth Circuit, the standard's always been recklessly indifferent. The debtor had to disregard some clear signs that the partner was a crook. The Eighth Circuit recognized that an earlier Supreme Court decision didn't require reckless behavior. The earlier Supreme Court decision just said if your partner's a crook, it's going to be imputed to you. We call that the innocent dupe. It seems to suggest to me that at least the Eighth Circuit would now consider even an innocent dupe liable for the crooked partner's debts. Jim already told you in a much more entertaining fashion the legacy of Anna Nicole. I won't spend a significant amount of time on that. I will just say that for those of you that have been wondering why at every pretrial conference, now I begin the pretrial conference by asking the parties whether they consent to my entering final conclusion or final findings of fact and conclusions of law for a final judgment. This is why. I don't want to have any dispute later on. The problem with the case is that no one ever raises the issue until they lose. Okay? Everyone's perfectly fine having the bankruptcy judge enter a final judgment if they win. But when they lose, then they raise the issue. And that's in fact what happened in a case that I did author for the BAP, and we held that you could waive the claim, and you could do so by implication. In this case, the losing party kept quiet for 5 years while the case was pending, didn't raise the argument until it was on appeal, and we just said, you impliedly consented to the bankruptcy court's entering a final judgment, we're moving on. We were hoping that that was going to get taken up to the Eighth Circuit for a final decision by them. For reasons that we don't understand, the appeal was not pursued. I mean, they filed a notice of appeal and they let it languish, and it was ultimately dismissed without the Eighth Circuit making a decision. Been 3 circuits to decide the issue so far. The 4th and I think the 6th said you cannot waive it, and the 9th Circuit said you can waive it. So of course, when I was writing that opinion, I went with the 9th Circuit who proved those other folks. The good or bad news, depending upon your perspective, is that the issue is now before the Supreme Court. The decision in the 9th Circuit case on which we relied on our BAP opinion is before them, and the issues that are going to be decided, we think, are does Article 3 permit the exercise of the judicial power of the United States by bankruptcy courts on the basis of litigant consent, and if so, is implied consent based on litigant's conduct, where the statutory scheme provides the litigant with notice that its consent is required sufficient to satisfy Article 3. And the second is, and more troublesome, frankly, may a bankruptcy judge submit proposed findings and conclusions of law for de novo review by a district court in a court proceeding under 28 U.S.C. 157b. The thinking was always that, okay, even if we don't have the authority to enter a final judgment on these state law counterclaims, we could do proposed findings and conclusions and submit them to the district court, and the district court judge would sign off on them. There's a possibility it may be found that we can't even do that. So then basically the district court's going to have to hear all these state court counterclaims. And as concerned as I am about the implications of the decision, I'm guessing the district court judges are even more concerned about it because I don't think they really want to be hearing these state law counterclaims in bankruptcy proceedings. But anyway, that's why I'm asking the questions at pretrials now. I'm not relying on implied consent. I'm trying to get express consent in the hope that at least maybe the express consent will get us past the problem. But we'll know more when the Bellingham Insurance Company case comes out of the Supreme Court. The real problem with the Supreme Court's decision in Stern is that while the holding was expressly limited to state law counterclaims, the analysis leads one to suspect that we can't enter final judgment on anything to do with state law. And for those of you that practice bankruptcy, think of all the state law issues that are implicated in any bankruptcy case. They're everywhere. So that's the scary part, that they decided, well, we should have just gone all the way the first time. It'll be an interesting area of practice for the coming years. We're getting close here. Call a couple more things to your attention. On page 10, we're talking about judgments and judgment liens. I think we're all aware that a judgment lien has a 10-year shelf life. I was actually surprised to learn in resolving the Sol case referred to in the materials that the judgment itself has a 20-year life, and you can use a writ of execution pursuant to that judgment for 20 years from the entry of the judgment. I always thought it was 10 years for the judgment lien, 10 years for the judgment to be renewed once, obviously. No, the judgment has a 20-year shelf life, and you can execute on it with a writ of execution for those full 20 years. It came up in this case because the question was whether or not the claim even existed anymore, or had the judgment represented the claim. The judgment had gone away according to the debtor, and therefore there was nothing left for the estate to pay. And I concluded otherwise based upon the statutes cited in the material. A new twist in South Dakota law as of last year, the discharge in a bankruptcy case does not no longer discharges the personal liability of the debtor. That takes place under the bankruptcy code. The personal liability is gone when the judgment is entered. With the amendment cited in the materials, now the discharge wipes out any judgment liens against the debtor's property. And that's a change in the law, because historically the bankruptcy code does not do that. The bankruptcy code does not discharge the in-rem liability. South Dakota law does now. So for those of you who have clients that get judgments and are happy and content with their judgment liens, and someone files bankruptcy, probably better tell them right off the bat that their judgment liens are going to go away, so that they're not surprised down the road when those judgment liens go away. It's not going to be good news for them, but it certainly is good news for debtors. And the better news, as far as I'm concerned, is I no longer have to deal with motions to discharge judgments. We were the only state that I'm aware of in the country, only district in the country that was doing that. And I hesitate to estimate how much time has honestly spent reviewing those. I know that every moment I spent reviewing them was a moment I wish I had back. So I'm not at all unhappy to see that that's no longer my responsibility. The state court's going to have it. Quick word on Schedule C. For those not familiar, Schedule C is where a debtor claims exemptions, the property that will be taken back out of the bankruptcy estate and kept by the debtor. We had a case, the Nesson case cited in the materials, that stands for, to me, the unsurprising proposition that if you claim $1 exemption in an asset, you get $1. Now, this went all the way to the 8th Circuit, so obviously it was not clear to someone that that's what happened. In this case, the debtor had a boat, motor, trailer, and a lawsuit, claimed $1 exempt in each. I told the trustee to cut a check for $3 and take the property, and away we went to the BAP and then ultimately to the 8th Circuit. The 8th Circuit affirmed my reading that when you claim $1, you get $1. The debtor's argument was, I claimed $1 in this glass, and even though the glass might be worth $5, you can't take the glass because I have $1 of it exempt. And the 8th Circuit affirmed that trustee can pay $1 and take the glass. So not exciting, but certainly important. It does point to one thing about exemptions. Exemptions are to be claimed carefully. If you have a joint filing, you now have $12,000 of exemptions to claim. You should claim $12,000 exempt. You can't claim unknown for your exempt amount. You can't claim full for your exemption amount. You have to claim a dollar amount. If you can't claim a dollar amount, the trustee's going to object, and I'm going to sustain. And at some point, the trustees are going to get tired to objecting to those kinds of exemptions, and I'm going to award fees. Because we all know better than that by now, and we should all be doing what the code requires. pet peeve of mine in this area is, and I know it's because of your petition preparation software, like I say, we have $12,000 exempt for joint filings. Consistently, attorneys will claim $13,400, $19,000. Everything on the Schedule B, the personal property, gets carried over to the Schedule C and it's claimed exempt. That's not in good faith. You get 12, claim 12. Do your math, do your homework, claim 12. Trustees are going to get tired of it eventually, and I'm going to have to do something about it. I don't want to have to do that. Now, having said that, I will tell you that if you claim $19,000 exempt and the trustee doesn't object, guess what you get exempt? $19,000. The Supreme Court says that whatever you claim exempt, if it's not objected to, you get it claimed exempt. So maybe what the debtor's attorney, maybe the debtor's attorneys are being more clever than I'm thinking. Maybe they're knowing that the Supreme Court says that they claim $19,000, they get $19,000 exempt. I'm just too trusting, I guess. But bottom line is, be aware of it, and if you're going to claim the 19, be prepared to make the argument that you are doing it in good faith in some fashion. Last thing I want to talk about, because we're not going to get, well, two more quick things, and they both have to do with counting.